How can heirs clear title when estate property was sold without their consent? In North Carolina, the first step is to review the deed and the probate history. If the deceased owner held the property with a valid right of survivorship, or as tenancy by the entirety with a spouse, the surviving spouse may have received full ownership at death. But if there was no survivorship and no will, the deceased owner's real estate usually passed to the heirs at death, subject to estate administration and lawful claims. That means the spouse may have inherited only a share. If there was one child, the spouse's share of the real property is usually 1/2. If there were 2 or more children, the spouse's share is usually 1/3, and the children share the rest. A surviving spouse generally cannot sell the children's inherited interests unless the children, and sometimes their spouses, signed the deed, or unless a personal representative or court-approved process had authority to transfer those interests. A life estate in the deed does not automatically wipe out the children's ownership rights. To clear title, heirs may need an estate filing, a corrective deed, a quiet title lawsuit, or a deed challenge if there was fraud, coercion, lack of capacity, or lack of authority. Because fraud and mistake claims can have strict deadlines, heirs should act as soon as they discover the title problem.